I'm broadcasting.
Hello. A very good morning to viewers across India. We are planning to have this webcast consequent to the corona virus lockdown. I think the first thing we need to understand is that what we cannot prevent, we have to accept, and therefore, accepting the corona 19 lockdown, we look at how we can make a difference in our own lives and in the lives of others. And this initiative is to see that we contribute to the learning of indirect taxes, specifically GST. Many of us in this period have introspected a lot, looked at those things which are more important rather than the urgent things we were normally occupied with. And one of them has been learning and empowering ourselves. Our small way of contributing in article started about 15 days back, and this online initiative is in two stages. Stage one is till 14th, and stage 2 will start after we understand whether and how the lockdown will be staggered open. We'll also be hosting this particular sessions in a day or two for everybody on YouTube. And if I were to look at this program, we are going to start with the Constitution of India, which is the mother of all the legislations in India. And for this, we'll have Advocate M S Nagaraja, who has had a unique career in 26 years in the armed forces and now 21 years in indirect taxes. He practices in the High Court and, of course, the tribunal, and has been a renowned pleader. He's also been we have been lucky to be associated with him for the last decade. The next will be understanding some of the key issues in levy. That is tomorrow by CA Rajesh, followed by a very important aspect of what service and goods can be said to be composite, what can be said to be non-composite, what can be said to be mixed, and understanding the difference between cross-charge and input service distributor concept in GST. Subsequent to that, we will be taking up the valuation, insights on some valuation issues in GST. I would be taking that, followed by ITC optimization based on the latest judicial decisions also by Sudhir, CA Sudhir from Hyderabad. The next session will be on the aspect of reverse charge, which has undergone a couple of changes by Ashish from Gurgaon, CA Ashish from Gurgaon, and assessment by an eminent faculty. The last session in this segment, that is stage 1 or part 1, would be departmental audits and notices, which have started, you can say, raining on the SSCs as of today, from Ashok Batra, Chartered Accountant from Delhi. I wish all of you a happy learning, and I invite Nagaraj sir to take over this session. Thank you very much.
Good morning, everybody. In the present context of nationalistic fervor, when we talk about India, when we talk about patriotism, when we talk about togetherness and the strength of unity, I think we should look at the preamble to the Constitution before we proceed any further. I'll just read out, because this is one of the unique preambles to Constitution of any country. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and to give to ourselves this Constitution. Now, this is what our forefathers, the Constituent Assembly, did to adopt the Constitution. Now, hereafter, we'll now concentrate on how the GST is part of the constitutional law and how the Constitution had to be amended in order to levy goods and services tax. Earlier, the taxation was either under the union list or state list or the concurrent list. Only the parliament or the state legislature could enact laws to levy taxes on the subjects which come within their jurisdiction. Now the parliament has been amending the constitution for quite some time. In fact, the GST amendment of the constitution is 101st amendment in 2016. For the amendment of the constitution, the parliament has to introduce a bill to be passed in each house by a majority of the total membership of that house and by a majority of not less than 2/3 of the members of that house present and voting, and thereafter assent by the president. Now the question came whether the parliament could amend the constitution. In February 1967, an 11 judges bench of the Honorable Supreme Court in Goraknath case held that the parliament has no power to amend part 3 of the constitution. Now, part 3 of the constitution refers to the fundamental rights. The Supreme Court held that the parliament cannot take away or abridge the fundamental rights of the citizens. Now, this was there for quite some time, and subsequently, in the Keshavananda Bharati Sripada Gadavaru case versus State of Kerala, a 13 judges constitution bench of the Supreme Court overruled the Golaknath case and held that the parliament has the capacity and competence to amend the constitution under Article 368. But then the Supreme Court also brought in the concept or the doctrine of basic structure or basic framework of the constitution. It is believed that Justice H.R. Khanna brought in this doctrine to hold that the amendments can be made subject to the condition that The laws made by the parliament or the state legislature does not transgress the basic structure or the basic framework of the constitution. This would enable that any law formed by the parliament or the legislatures are subject to judicial review. Any law which transgresses the basic structure or the basic framework of the constitution are liable to be struck down. Now, this is the law which now holds the field. As I mentioned earlier, the parliament did not have the competence to levy tax on goods and services. It may be recalled that the indirect taxes were levied like customs duty under entry number 83 of the union list, and in case of central excise duty under entry 97 of the union list. In fact, the entry number 97 is a residual entry which empowers that any subject which is not specified in either list 2, that is the state list, or list 3, the concurrent list, can be subjected to tax by the union. Therefore, when the government decided that the goods and services tax must be levied on the goods and services, subsuming a number of central and state taxes, then the constitution had to be amended to empower the parliament and the state to concurrently levy tax on goods and services. Therefore, Article 246A, a special provision with respect to goods and services tax, was introduced through 101 amendment of the Constitution in 2016. Now, 246A says, notwithstanding anything contained in Article 246 and 254, Parliament, and subject to Clause 2, the legislature of every state have power to make laws with respect to goods and services tax imposed by the union or by such state. It may be seen that both the central government, that is the parliament, as well as the state legislature, have the concurrent power or equal power to levy tax on the supply of goods and services. The subsection 2, however, restricts the power of the state legislatures by empowering parliament to have exclusive power to make laws for levy of taxes on interstate supplies. Interstate supplies between the states or in the course of import or export. Article 246A, if you have seen, starts with a non-obstant clause, thereby empowering the parliament and the legislatures to make laws with respect to GST, notwithstanding the separation of powers in terms of Article 246 and Article 254. So they have the concurrent jurisdiction. That is why we have the central GST, then the state GST, and the union territory GST. All of them are modeled identically, and the rate of tax is also identical. only the Parliament has exclusive power to levy tax on supplies in the course of interstate transactions, including imports and exports. Article 246 is the limiting factor. Earlier, for the taxation purpose, the Parliament could make laws only on the subject matters which are listed in List 1, popularly known as the Union List, and the state legislature could make laws on the subject matters in List 2, that is the State List, and both the Parliament and the state had powers to make laws on the matters in the List 3, the concurrent list of the 7th schedule. Now, wherever there is a inconsistency in the laws made by the legislature with the laws made by the Parliament, the law made by the Parliament will always supersede the law made by the state legislature, or the Parliament could enact separate laws on the subject. Article 279(5) was introduced to say that in respect of the petroleum products are the petroleum crude, high-speed diesel oil, motor spirit or the petrol, natural gas, and ATF. The provisions for GST or the levy of GST would take place on a date to be recommended by the GST Council. Though there is some clamor for inclusion of the petroleum products within the scope of GST, the revenue considerations, I think, will put a hold on that, and the present system may continue for quite some time. Article 248 was amended to enable Parliament to have the exclusive power to make any law, including taxes, with respect to any matter not enumerated in the concurrent list or the state list. Of course, this law-making powers are subject to Article 246A. Article 249 and Article 250 empower the Parliament to make law subject to the conditions with regard to any matter contained in the state list, including the laws required to be made during an emergency. These articles have been amended to include specifically GST along with any other matter contained in the state list. The medicinal and toiletry preparations containing alcohol were subject to levy of tax under a separate act. Levy was by the central government and the duties were collected by the state government. And this has been omitted since the medicinal and toiletry preparations subjected to excise duty have also been subsumed in the GST from 2017. Article 269, which was related to the levy of CST on interstate sale or purchase of goods, as it existed prior to 2017, is made subject to the Article 269A. You're aware now that IGST is levied on the interstate supplies, which are the exclusive domain of the central government. The state government cannot levy IGST on any intrastate supplies. The interstate supplies are exclusively coming within the legislative competence and powers of the union. The tax collected, the IGST collected, is a portion between the central government, between the union and the state governments in the manner to be provided by the parliament by law on the recommendations of the GST Council. In case of imports, the supply of goods or of services are both in the course of import into India is deemed to be supplies in the course of interstate trade or commerce, and therefore the union has the exclusive power to levy tax on such imports. On imports, you are aware that the custom duties are paid, which includes the basic custom duty and also the IGST leviable in terms of the Customs Tariff Act. The Parliament has the power to formulate the principles of place of supply and the time of supply in the course of interstate supplies, including the imports and exports. Article 270 deals with distribution of taxes levied and collected by the central government and how the taxes collected by the government is distributed or shared between the union and the states as recommended by the Finance Commission. Under Article 270, subclass 1A and 1B have been inserted to facilitate the distribution of the GST relating to the interstate supplies. Article 279A is an important provision. It deals with how the GST Council is constituted by the President. The article provided that as soon as the amendment was passed, the President must constitute the GST Council. Within 60 days from the date of commencement of the Constitution 101st Amendment Act 2016, the President was required to constitute the GST Council, which has in fact been done. The Council consists of the Union Finance Minister as the chairperson, and the state finance ministers are ministers in charge of the finance or taxation or any other minister nominated by the state government to be the members. The members of the council will choose one among them as the vice chair. So therefore, the GST Council comprises of the chairperson, the Union Finance Minister, a vice chairman, and members of all the states and the union territories. Now, how the decisions are to be taken? Now, this also has been constitutionally laid down to say that the GST Council shall take a decision by the majority of not less than 3/4 of the weighted votes of the members present and voting. Of course, the members constitute half of the members of the council constitute the quorum, and the union's finance minister and the state finance minister have 33.33% of the share of vote, and all of the state governments put together comprise of the balance 2/3 of the voting power. The GST Council during their meetings as often as necessary, but at least once in 3 months. They make recommendations to the government for implementation. Therefore, it appears that constitutionally, the recommendations of the GST Council are binding on the union government and the state governments, and the governments are only required to implement those decisions. So once a decision is taken by the council, if there is a delay in implementation, like it happened in the case of levy of interest under section 50, what will be the course of litigation? Whether the notification implementing the decision of the council will prevail, or the date of decision and recommendation by the council will prevail. I mean, these are the issues which are yet to be judicially scrutinized. The council has an obligation or a duty to make recommendations on the taxes, cesses, and surcharges levied by the union and the states and the local bodies, which may be subsumed in the GST. The goods and services which are to be subjected to tax and which are to be exempted from the GST. The extent of exemption, whether it should be a partial exemption, or it should be an abatement, or it should be a full exemption, is to be decided by and recommended by the council. Formulation of the model GST laws, which are to be adopted by the union and the states, union territories, the principles which must be underlying the levy of taxes, the manner of apportionment of IGST between the union and the states, and the principles that govern the place of supply of goods and services. Now, these are the subjects of consideration and recommendations to be made by the council. The council also decides on the threshold limit of the turnover, below which the GST will not be leviable. The small scale exemptions or the extent of exemptions to be granted is to be decided by the council. The rate which is to be adopted for the class of goods is to be decided. Special rate or rates for the specified period, or the manner in which the additional revenues must be raised during any natural calamity or disaster, something through which we are now going through. The provisions of the laws with respect to the states, northeastern states and J&K, and also the states like Himachal Pradesh and Uttarakhand. Now, how the GST laws must be implemented, and certain provisions of exemptions available under the erstwhile GST, erstwhile excise duty, and the service tax must be brought into implementation, have to be decided by the council. The council may consider any other matter as it may decide. As regards the petroleum products, we talked about the crude oil, HSD, petrol, natural gas, ATF. Though they are included in the schedules, but the rate of tax and when the applicability of GST is yet to be decided. The council will have to examine and decide as to the date from which GST will be levied on these petroleum products. Now, how should the GST consider various recommendations, and if there is a dispute between the central government and the state government, or between the central government and a few of the state governments on one side and other state governments on the other side, or between the state governments, have also been laid down in the constitution itself. The objective of the GST Council is that there must be a harmonized structure of GST and for the development of a harmonized national market for the goods and services. That is why the government often says that one nation, one tax is the objective behind levy of GST. As far as the dispute resolution is concerned, the GST Council should establish a mechanism to adjudicate the disputes between the union and the states, or union and states on one side and a few states on the other side, or between the states, in respect of any recommendation made by the council or its implementation. Once some recommendations have been made by the council, and during implementation, if there are difficulties and if there are disputes, the council must examine them and resolve those disputes satisfactorily. These are all the constitutional obligations of the GST Council. Article 286 has also been amended. According to the amended Article 286, the state shall not have power to levy tax on supply of goods or services or both, where the supply takes place outside the state, that is, originating in one state and the supply taking place in another state, or the entire transaction taking place outside the state, or in the course of import of goods or services or both into India or export of goods. As we discussed earlier, the Parliament has got exclusive power to levy taxes on interstate supplies, including import of goods or services or export of goods and services out of the territory of India. The state governments have power only to levy tax on the intrastate, that is within the state, supply of goods or services or both, because that is the transaction taking place within the state, the taxes on which must accrue to the state government. Article 366 contains definitions of a number of terms which are used in the Constitution. This also has been amended to include the definitions of certain terms. GST means any tax on supply of goods or services or both, except taxes on the supply of alcoholic beverages for human consumption. As far as the liquor is concerned, alcoholic beverages which are consumed by people continue to be subject to excise duty under the state law. It is outside the levy of GST. Service means anything other than goods. So this is a constitutional definition. Anything other than goods is a service. Very wide amplitude, which has been the subject of a large number of disputes as to whether a particular activity constitutes service or not. State, when there is a reference to the term state, it includes union territory with the legislature. The Article 368 was also amended to provide for amendment of the Constitution. For a parliament to amend the Constitution and what the procedure should be has been laid down in Article 368. As I mentioned to you earlier, Article 368 and the powers of the parliament to amend Constitution has been the subject matter of great deal of litigation. And it is the 13-judge Constitution bench in Keshavanand Bharati's case, which has propounded the doctrine of basic structure, a basic framework, which forms the basis of the Constitution, and any amendment made to the Constitution which alters the basic structure of the Constitution is liable to be struck down. Now, any amendment of the Constitution may be initiated by a bill to be introduced in the Parliament, and the bill is to be passed in each house by a majority of the total membership of that house and a majority of not less than 2/3 of the members present and voting in the house. And it must be passed by both the houses and thereafter receive assent of the president. Now, 7th schedule is the one which contains various subjects on which the center and the state has power to levy taxes. As I mentioned earlier, it has union list, list 1, state list, list 2, and concurrent list, list 3. 7th schedule has also been amended for the parliament to levy excise duty on the petroleum products, crude petroleum oil, HSD, motor spirit or the petrol, natural gases, ATF, tobacco and tobacco products, which are also liable to GST. In the 7th schedule, the levy of tax on sale or purchase of newspaper and advertisement published therein in the union list, entry number 92 has been omitted. Entry 92C is taxes and services. State list was to contain the power of the state government to levy tax on entry of goods, entry tax. That has also been omitted. In the state list, entry 54 is restricted to levy of tax on sale of the petroleum products only and alcoholic beverages for human consumption, along with excise duty under the State Act. The power of the state to levy tax on advertisement, other than in newspapers and advertisements broadcast by radio or television has been omitted. Power of the state to levy taxes on luxuries, including taxes on entertainment, amusement park, betting and gambling, has also been restricted to taxes on entertainments and amusements to the extent taxes are levied and collected by the panchayat or a municipality or a regional council or a district council. The local bodies of states of Assam, Meghalaya, Tripura, and Mizoram are empowered to levy certain taxes, along with taxes on entertainment and amusements. Section 18 of the 101st Amendment Act empowered Parliament to enact a law as recommended by the GST Council to compensate the states for the loss of revenue incurred due to the implementation of GST up to a period of 5 years. On the basis and on the strength of Section 18 of the Amendment Act, we now have the GST Compensation Cess Act 2017, under which the compensation cess is levied. Now, we have been talking about the amendment of the Constitution. We have been talking about CGST Act, IGST Act, compensation cess. Are they constitutionally valid? The validity of the Central Act as well as the State and Union Territory Acts have been briefly examined by the Supreme Court. The Supreme Court, in the case of Union of India versus Mohit Minerals in December 2018, has upheld the constitutional validity of the Act. As we mentioned, as we discussed earlier, any amendment to the Constitution must not transgress the basic structure of the Constitution. And the 13 judges bench of the Honorable Supreme Court in Keshwananda Bharati's case has held that the basic structure includes independence of the judiciary and the power to judicially examine each law passed by the Parliament or the legislature. The Supreme Court thus has the power to judicially examine the legislation passed by the Parliament and confirm whether it is consistent with the constitutional provisions or transgresses that basic structure of the Constitution. Delhi High Court had passed certain judgment with regard to levy of compensation cess, even though the cess had already been paid, clean energy cess had already been paid on extraction of coal. Against the Delhi High Court judgment, the Union of India had filed a civil petition before the Supreme Court, justifying the levy of compensation cess under the Compensation Cess Act. The Supreme Court, in its judgment in December 2018, has examined a number of issues, which includes the constitutional amendment via Article 246A and the CGST Act 2017 and the Compensation Cess Act 2017 and held them to be constitutionally valid. Therefore, the validity of the GST laws have also been scrutinized by the Supreme Court and has been held to be constitutionally valid. If there are any questions, we can, if there are any issues, we can discuss it before we conclude. Yeah, the issues which have been is 101st Constitution Amendment Act empowers Parliament to levy compensation cess Mohit Minerals case. This is what I examined. I was mentioning now. The Compensation Cess Act 2017 has been upheld, and the Supreme Court has held that clean energy cess and the compensation cess are two independent levies, and the Parliament has the constitutional power to levy cess in both the cases. So the Mohit Minerals case has decided the issue and in favor of the upholding the Compensation Cess Act. The second is old credit saved by section 174(2)(c) of the GST Act, read with repeal provisions of General Clauses Act completely or further subject to condition restrictions in various provisions of GST like section 140. Now this issue may not have any relevance to the constitutional amendment as such. It is entirely the provisions of the CGST Act, section 174 versus section 140. So it may not be relevant as far as the Constitution is concerned. But nonetheless, the credit saved by section 174, I think this question is a little not very clear. What it says is old credits saved by section 174(2)(c) of the GST Act, read with repeal provisions of General Clauses Act, completely or further subject to condition restrictions in various provisions of GST like section 140. See, as far as the credit earned earlier prior to introduction of GST, which is carried forward to GST, is governed by the transitional provisions. Beyond the transitional provision, there is nothing else. The applicability of General Clauses Act or repeal provisions may not be relevant at all. The only relevant consideration would be whether you are eligible to credit under the existing law, that is under the excise or the service tax law, whether it has been validly taken, and whether you can carry forward the credit through Tran 1 provision, the mechanism that was provided through Tran 1. Beyond that, there are no other restrictions. The next question is there any difference between supplies in the course of interstate trade or commerce and interstate supplies? Wordings in Article 269A. If you see Article 269A, it talks about supplies in the course of interstate trade or commerce, generally referred to as interstate supplies. Yes, sir. 269A says goods and services tax and supplies in the course of interstate trade or commerce shall be levied and collected by the government of India. Now, what is the interstate trade or commerce? That means it must be a transaction interstate between the states in the course of trading or as a commercial transaction. It should not be a case of import by a private person for his personal consumption. It must be in relation to trading or commercial transaction. Now, whether it is called interstate trade or commerce or interstate transactions which come within the meaning of supply, because the supply itself, definition of supply itself is in relation to no, not other slide. We'll go back to the earlier. Yeah. So supplies in the course of interstate trade or commerce and interstate supplies mean the same, one and the same. The usage, interstate supplies, the meaning or definition of supply itself. If you see the definition of supply, it shows very clearly that it is always in the course of interstate. All forms of supply of goods or services of both, such as sale, transfer, barter, exchange, license, rental, lease, or disposal made or agreed to be made for a consideration by a person in the course or furtherance of business. So that means it must be interstate trade, the transactions in the nature of interstate transactions must be in the course of commercial transactions, trading or commercial transactions. Next question. Next question is section 174 in bracket 2 in bracket E is ultra-wise section 19 of the 101 first Constitution Amendment Act. Now let's see 174, what you are referring to. Yes, section 174 talks about repeal and saving. 174(2)(e) refers to the repeal of the said acts and amendment of the Finance Act 1994, as the case may be, to the extent mentioned in subsection 1 or section 173 shall not affect any investigation, inquiry, verification, including scrutiny and audit, assessment proceedings, adjudication, and any other legal proceedings, or recovery of arrears, or remedy in respect of any such duty, tax, surcharge, penalty, fine, interest, right, privilege, obligation, liability, forfeiture, or punishment, as aforesaid, and any such investigation, inquiry, verification, including scrutiny and audit, assessment proceedings, adjudication, and other legal proceedings, or recovery of arrears or remedy may be instituted, continued, or enforced, and any such tax, surcharge, penalty, fine, interest, forfeiture, or punishment may be levied or imposed as if these acts had not been so amended or repealed. Now, the question is, go to the question. Section 19 of the 101st Constitution Amendment Act. Yeah. Yeah. 19, Section 19 of the 101st Amendment Act says, notwithstanding anything in this Act, any provision of any law relating to tax on goods or services or on both in force in any state immediately before the commencement of this act, which is inconsistent with the provisions of the Constitution as amended by this act, shall continue to be in force until amended or repealed by a competent legislature or other competent authority, or until expiration of 1 year from such commencement, whichever is earlier. No, I don't see any contradiction between the two. All that the section 174 says is, any action, any liability that accrues, that has arisen in the context of the existing law, either under the Central Excise Act or the Finance Act or any other law, will remain unaffected. It cannot be said that because the law has been repealed or it has been omitted without a saving clause, those liabilities will get extinguished, or any advantage that has accrued has also got extinguished. The repeal and saving only says that whatever has accrued till 30th June 2017 will continue to be existing, and any proceedings initiated, any recoveries can be made, any demands can be made, any action can be made in accordance with the law existing on the date of its occurrence, that is prior to 30th June 2017. As far as section 19 of the Act, Amendment Act is concerned, it says notwithstanding anything in this Act. That means nothing contained in the Amendment Act, any provision of law relating to tax on goods or services or both in force in any state immediately before the commencement of this Act, which is inconsistent with the provisions of the Constitution as amended by this Act, shall continue to be in force. That means they have kept those laws alive. Just like section 174, saving clauses are there. Section 19 of the Amendment Act also has saved those provisions, even if they are inconsistent with the provisions of the Constitution. Yeah. Significance of the next question is significance of the word instituted in section 174(2)(e). Therefore, fresh proceedings cannot be initiated, and existing proceedings as on 30/6/2020 can be continued. See, instituted, you are only going by the term instituted. That means you are trying to say that if something was instituted prior to, then only it will survive and not otherwise. No, but we should also read into these provisions the limitation provisions. The limitation provisions available under those acts will continue to be applicable. They can institute within the limitation, normal period of limitation or extended period of limitation as applicable under the earlier laws, existing laws. I don't think there should be any significance for the term is instituted. It also includes, yeah.
There are two questions.
Yeah.
Same thing? This is different.
Yeah.
Through 246.
Now the next question is, why through Article 246A and not through existing central concurrent list? The excise duty and the service tax, if you recollect, were levied under entry number 97 of union list. 97 was a residual entry, which says that any subject which is not mentioned in either list 2 or list 3 could be subjected to levy of tax by the union. The concept of GST was taxation by both the center as well as the state on the same transaction. The neither list 1 nor list 2 nor list 3 contain any provision where both the central, the parliament as well as the legislature, state legislature, could simultaneously levy taxes on the same transaction. Therefore, it had to have the sanction of the parliament and also the state legislatures for simultaneous levy of the tax. Therefore, the constitution had to be amended. Next question is whether Article 366(29)(a) still survives. Yes, absolutely. If you see the Supreme Court judgment in the context of Calcutta Club, Ranchi Club, where they have said the principle of mutuality as canvassed, as constitutionally held, and under Article 369(29)(a) still survives. There has to be a transaction of supply by one person to another. The principle of mutuality will definitely will continue to be applicable. That is what the larger bench of the Supreme Court in Ranchi the Calcutta Club or Ranchi Calcutta Club case has confirmed once again. Even after the amendment, the principle of mutuality will continue to be valid. The next question is, when Kerala imposed Kerala flood cess, was it approved by the entire GST Council? Yes, it was approved. As a matter of fact, the GST Council had recommended that the Kerala government may levy tax, and they had also specified the rate of tax which is to be levied by them. Is approval of Parliament necessary for the recommendation made by the Council? Not required. The GST Council has now the constitutional mandate to decide on various issues which have been particularized in the Constitution itself. The Council has to decide what should be the rate of tax, the extent of exemption, the broadbanding, the width of the exemption or width of the tax base. Everything is within the powers of the GST Council. That is why, if you recollect, the finance bill or the budget, annual budget, has lost its significance because the decisions are now by the GST Council and not by the government or by the Parliament. Parliament can amend the law once again if they want to curtail the powers of the GST Council, and that amendment once again amounts to constitutional amendment. Therefore, there is no requirement for the Parliament to approve any recommendation made by the Council. Next, is there any goods or services which is subject to abatement in GST? Yes, there are a number of goods and services which are subject to abatements. Any example that we can give? Are there any goods or services which is subject to abatement in GST? Like, for example, GTA service, common GTA service. There is a leasing of vehicles. So there are goods and services which are subject to, which have certain abatement, partial exemptions are available. Can a state, central government unilaterally amend the GST Act? No, it has to be, the amendment of the GST Act has to be on the recommendations of the GST Council. Otherwise, the amendments will become unconstitutional. I am Amit from BHEL, Hyderabad. Need clarity on difference between import and in the course of import. So you'll have to go to the definition of import under the Customs Act. When we say import, it is the process through which the goods are brought brought into India. That is the landmass of India. In the course of import, could be the transaction which is not complete yet, where the goods or services have not reached the destination. It has not crossed the customs frontier, customs barrier. So that is in the course of import. Therefore, the difference is import is always refers to the general understanding of something coming from outside India, and the term in the course of import means in the process of being imported into India. Next question. There are concerns among lessor as to whether they need to discharge GST on rentals under current scenario where they may not receive the rent or they may receive less than the agreed amount. Are there any provisions in GST law enabling suppliers to invoke force majeure against the law?
Force majeure.
See, force majeure, yes, but one can invoke force majeure, but the taxation law does not provide for force majeure. The person who is liable to pay the tax has to pay the tax as soon as the time of supply and the place of supply has crystallized. Because you have not received the rent, it does not mean that you are not liable to tax. The payment of tax on realization basis, went a long time ago. Now it is the time of supply and the place of supply which will determine whether you are liable to pay the tax or not. Please share PDF after completing the session.
Organize.
Yes, it will be done. You will have the slides for your.
Organizers.
Yes, organizers will do that. One of the products imported was earlier exempt from tax in excise. Even in the first year of implementation of GST, levy was 0. After a period of time, the customs started levying 18% as there was no clarity about the product in GST law. Is there any way that we can approach GST Council to provide clarity on the rate of tax on the product? Definitely. If you indicate the type of goods or the service which are not liable to tax during the earlier regime and also under the GST, and it has now been subjected to tax, whether it is by virtue of any interpretational difference or a conscious levy of tax by the GST Council, that could be sought clarification from either the jurisdictional authorities or from the GST Council if it is so warranted. Next, do we not require payment of cess under GST Compensation Cess Act after 5 years? See, as of now, the constitutional amendment only provides for compensation cess for a period of 5 years. Now, if the GST Council extends it or curtails it, is entirely up to the GST Council how they will going to decide. I mean, there's more a speculation. Meaning of goods under Constitution is the same which is defined under the GST law. Yes, I suppose so, because the goods and the services have been defined in the Constitution, and as far as the Constitution provisions are concerned, those definitions will hold good. In Assam, tax in the form of mandi tax, marketing tax, and agricultural products, why is the taxes not abolished completely after GST implementation? Now that has been provided for in the Amendment Act itself. And if you see one of the last slides that I was showing you, some of the states in northeastern states have been empowered to levy certain local taxes on the goods and services. Now, why they have not subsumed them in GST is perhaps for the GST Council to examine and decide whether it is a conscious decision or they have left it to the authority, the state governments to tax those activities. How does the GST compensation cess works? GST compensation cess works on certain goods which are specified, and these goods are, say, for example, automobiles or certain luxury products, tobacco products, sin goods. So these are the goods which have been listed in the schedule, which is attracting compensation cess in addition to the GST that is leviable. From which article it appears that recommendations to the council are mandatory. The go to the slide. 279. See, when you read the constitution of the council,
Need 279A.
amendment, presentation.
Yeah.
Go to the presentation. See, Article 279A very clearly says what are the duties and obligations of the council and how the council will make recommendation, how they will examine, what issues they will examine. The one of the recommendations of the council concerns the taxes, cesses, surcharges levied by the union, states, and the local bodies which are subsumed. So, what is to be subsumed and what are the taxes and cess to be surcharge to be levied are all decided by the GST Council. Article 279A. Section 16 of the CAA empowers district council to levy tax on entertainment or amusement. At the same time, section 217 business definition includes admission to premises. There appears to be duplication of tax on this subject. Please clarify. See, the as far as the section 217 is concerned, it talks about admission for a consideration of persons to any premises. Admission to premises. Now, the mere admission to any premises, any admission to premises is entirely different from admission to an amusement park or an entertainment park. Okay, these are two different different purposes for which the taxes may be levied. Will you provide PPT? Yes, it will be provided by the organizers. Is real estate was always covered under the definition of service? See, real estate, I mean, it is a very vague term because real estate is essentially an immovable property. Leasing of a real estate or licensing it or transfer of development rights, some of these which are not transactions of sale of real estate or immovable property, they have been subjected to service tax earlier, and even now they continue to be liable to tax. Where the GST overrides 7th schedule as 246A is notwithstanding to 246. 246A is the constitutional provision which empowers levy of tax on the on the goods, on the supply of goods and services. So this has nothing to do with Article 246. When a beneficial amendment like interest on net basis is passed, will this have to be considered at retrospective clarification or prospective? See this, you may refer to the GST Council recommendation which has been made once again, that it has been made retrospective from the beginning. As a matter of fact, this is also based on the Madras High Court judgment in refer case, reflex case, where the High Court has already considered the provision that was enacted under Section 50 to say that the provision is more in the nature of a clarification and therefore retrospective. Whether central government can impose any other sort of tax like cess under any other law on goods or services. Yes, they are empowered to, the GST Council will have to decide whether they want to levy any tax, cess or surcharge on any goods or supplies. The council can make recommendation based on which the central government and the state government together simultaneously can levy the taxes. How do you see levy of GST on immovable property given that entry 49 of state list has not been amended? Can there be dual levy of GST and stamp duty of immovable property in future, having the definition of services inserted to Constitution by Article 366, 26A? See, as far as it should be 29A. As far as the levy of tax under GST is concerned, it is on the services in relation to immovable property and not immovable property per se. Therefore, one has to make a distinction between the transaction of sale of immovable property on which stamp duty is leviable and the transaction of service in relation to or in connection with the transactions of immovable property. Both are constitutionally valid because as a matter of fact, Supreme Court in Tamil Nadu Kalyan Mandapam case has very clearly held that the hiring or renting of Kalyan Mandap is a service and not a transaction of immovable property, and the levy of service tax has been constitutionally upheld. Whether service, can there be a levy of entry tax in future? The entry tax has already been subsumed in the GST, and as of now there is no entry tax. What holds in future, I mean, it's more a speculation. Can there be a levy of CGST department is conducting audit of an assessee, and they notice that though RCM under section 9(4) is done away with effect from 13/10/2017, but the assessee has still paid RCM under section 9(4) till 31/3/2018. See, as far as the query is concerned, this is a very specific query in relation to certain other issues which are not been which are not been the subject of our discussion this morning. Yeah.
Many of the questions which are there are not related to the Constitution. They become general questions, and therefore what we will do is we'll take some specific questions on the Constitution itself. Nagaraj sir,
Yes, sir.
what is the impact of the Supreme Court decisions? Because Article 141 talks about the law laid down by Supreme Court. Can you shed some light on this?
See, under Article 141 and 142, the law declared with the Supreme Court is binding on all courts and all authorities. as far as any judgment by the Supreme Court is concerned, under the, are you referring to the GST?
Yes, GST.
Yeah. In case the issues on which the Supreme Court has rendered judgment are similar to the issue which may arise under GST, those judgments will have a bearing. As far as the applicability or the persuasive value or the binding precedents, I mean, these are the things one has to look at. Whether if the same issue has been decided by the Supreme Court, then it will be a binding precedent. If it is somewhat related issue, then it may have certain persuasive value, or it may have defined certain terms or defined certain phrases, or it may have made a mention about certain issues as obiter. In those cases, it may have some bearing on the subject. But then, yes, the views of the Supreme Court are always very persuasive and binding.
Sir, this GST Council has got a lot of powers, and are those powers unfettered? Can they be judicially challenged?
Yes. Yes, I see. As far as the GST Council is concerned, it is one more constitutional body which is empowered to examine the issues, make recommendations to the government for implementation. When the recommendations are implemented, they are again subject to judicial review. That is the basic structure of the Constitution. Every decision, every implementation of the decision of the Council is subject to judicial review, and it can be challenged before any High Court or the Supreme Court, either under Article 2 to 6 before the High Court or under Article 31 before the Supreme Court.
Sir, in a specific case of this ENA, which is a problem area for sugar industry, some state governments have taken a view that they will collect taxes as VAT. Many states have not done so. This has led to unequal treatment of this, and GST Council has kept it pending. Now, what would be the position if it is kept pending? Would the liability under the VAT survive or excise survive?
Yeah. See, as far as the VAT is concerned, the VAT got extinguished from 1st July 2017. As far as the ENA is concerned, its liability as far as the VAT is concerned is only up to 30th June 2017, and thereafter levy of GST has taken over. As far as the inequality is concerned, this could be a subject of litigation before the High Court. Could be a cause of action for the High Courts to give directions, request the High Court to issue a writ for the GST Council to take an early decision or within a certain time frame.
What happens in the meantime, sir? If I have paid the taxes, others are not paying, I am going out of business because of this.
Yes, this is a problem that one has to face only because there doesn't appear to be any solution as such.
The last question we will, sir, if you can take. Nowadays, sometimes a few officers, they threaten the SSCs with arrest, and sometimes without having adequate cause as per the SSC, or on some interpretational issues. They will say that your interpretation is not correct. Based on that, the total amount you have evaded is more than 10 crores, and they attempt to put you inside. Sometimes they do put you inside also. So how will Article 22 of the Constitution, how will that protect in such cases, and what you would recommend anybody to do if they are faced with such threats of arrest?
See, as far as the arrest is concerned, there are certain conditions which are very clear in the GST. See, section 69 of the CGST Act has very clearly says, where the commissioner has reason to believe that a person has committed any offence specified in clause A, B, and C and D. That means the person has supplied the goods without payment of tax, or has issued invoices without supplying goods or services, or somebody has taken the credit without having received the goods or services. These are very serious offences, where the culpability of the individual becomes very loud and clear, and the person may not have much defense against an allegation of this nature. Now, if the person is not guilty of any of these offences, the question of being threatened with arrest doesn't even arise. And if there is documentary evidence to show that the person has not supplied goods or services without, or there is an evasion of tax, the straight solution would be to project those, submit those defenses before the commissioner, and if the commissioner is not satisfactory and the response is not satisfactory, then go before the High Court. There is no other alternative, but you should be very clear about the quality and the type of evidence that you have in your favor to show that you are not guilty of any of those offences which are listed under section 132 and section 69 A, B, C, D, that which are there, which are clearly evasion of taxes.
Thank you, Nagaraj sir, for clarifying all our doubts. The ones which are missed would be answered separately little later by Nagaraj sir, and we will be sharing that with you. There is one, while you look at this, you could also look at various articles written on these subjects. In fact, there was a discourse by Nagaraj sir himself on certain aspects earlier on the levy, sir. You had spoken, and that has also been summarized in articles which are there on the blog, irrevenue.com blog, you will find it. We also would like to invite your attention to certain analytical or analytical summaries made which are there in the blog. Ideally, next session onwards, please ask questions which are related to the topic, so that we will go in depth there rather than asking general questions. We are very happy that we have had a full house, and we will hope to put this in the common maybe YouTube channel or some our blog itself if possible, so that those of your friends who have not been able to attend this session and also may not be eligible to attend the rest of the sessions which we have in this first part, they could also take advantage of it, but this would be done after 2 days. Thank you very much, viewers, and have a good day.
Thank you very much. Stay home and stay safe.